Good day, everybody. Welcome to the Entheogenic Esquire podcast and YouTube channel. I'm attorney Greg Lake. Very pleased and honored to be here with you today. I see that I have some of my regular subscribers already here. Let me shift my chair just a little bit. I see I already have some of my regular subscribers here with me. How are y'all doing? Very nice to see you. Thank everyone for the support. If you haven't already, please subscribe. Comment with us here. All the support really helps. Very much appreciate it. Creeping up on 900 subscribers. Man, I'm very smitten. I'm getting up towards the 3,500 view hours, which will be like the requirement for the partnership program with YouTube. And so things are moving along great. And I'm just very grateful. So thank y'all very much. And comments, it's been just a pleasure going back and forth with y'all in the comments. And, I hope we can keep that energy going. I really intend to keep this channel on the positive end if we can, as far as like the energetics with the videos, even considering a lot of the seemingly dark stuff that we're going to, I'd like to keep the energy as positive as we can. Let's try to make this channel a place where everyone can come together and feel accepted, and that we can sit down and talk about these things rationally, objectively, and, really get stuff done, because I feel with the situation that we're in right now in this country, it's really going to take us, putting our egos aside and really coming together and figure out where we can, come into alignment to, make this country a better place, for sure. So anyways, thank y'all. Tonight, as indicated with my thumbnail, I hope y'all are liking some of the AI thumbnails that I'm doing. I just started with Adam Thomas. Make sure I get this right. Adam Thomas. So Adam Thomas podcast. Me and him have been texting. We're going to do a live stream soon. He put me on to trying to use Chat GPT for the thumbnails. And so, just trying it out. We'll see what works or whatever. But anyways, thank y'all. So tonight's going to be discussing, as I indicated in the last live stream, we're going to be talking about really, it's a string of motions, but there's really two different things that the defense attorneys have filed, which the media and the state have opposed, that we're going to be talking, and it relates to public disclosure or public access to the proceedings in the Tyler Robinson case. Okay. So there's two different motions. So the first one we're going to discuss was a private motion filed by Tyler Robinson's defense team on January 9th. And with that motion was also a motion to consider that motion to be private, basically sealing it into the court record. And then the second one is another motion to exclude cameras. Basically, the way I take it, again, this was also filed as private. And let me do a caveat there, is that, this exchange filing system is pretty confusing. So I'm consistently, almost on a daily basis, going through it, combing through it, and trying to access everything that I can that's like not private or that makes sense to me to bring to you, right? So I just want to give that caveat. I'm pretty sure I got most everything that I'll need to appropriately address the issues tonight, but it's just the way that it is. But again, this second motion has to do with excluding the cameras, basically from, I want to say, pretty much every bit of the proceeding from here on out, like in the courtroom, which is obviously being opposed by the media. And as we'll see, they also want the motion and the hearing to be in private for a judge to rule on it. So again, we'll sort all this out. And before I get started, I'll just say that with the defense motions being private, and the responses from the news media and the prosecutor don't really go into the details of the defense motions, we're going to be guessing a little bit. Well, we're actually going to be more or less pure speculation on what, for instance, this substantive motion is that's been filed. That's they're trying to classify it as private. We have a pretty good idea that it's a motion related to the admissibility of evidence, either going to be a motion in limine or suppression motion. I'll explain the difference between those to y'all as we go through it tonight. But yeah, so what we're going to start with is the motion to keep private this January 9th, 2026 motion that was filed. And again, this was a motion apparently that relates to, evidence, whether it's admissible or not, again, which could come in a couple different formats, pre-trial. So we'll talk about that. But So let me grab my bearings here. So yeah, so on January 9th, the defense filed a motion and apparently challenging the admissibility of evidence. And then they filed the attendant motion to classify. Now, here's in the media filed a memorandum in opposition, and here are kind of their first couple points of contention with it, beyond the fact that, hey, this is supposed to be open to the public. So, anyways, what happened is that the defense filed the motion on 1/9, and then on 1/12, the court issued an order keeping it private. Okay, so that was, I think the 1/9 was maybe on a Thursday or Friday, and then like by the following Monday, the judge had ruled to keep that motion private. Now, the news media took immediate issue with this. If y'all remember correctly, I believe it was last live stream, I discussed the judge has a standing order wherein any motion to keep a document private, the media has to have 7 days to be able to respond to it, supposed to, before the court issues an order. Okay. And so that was not done here. And so obviously that was the media's first point of contention with the court's order keeping it private. And then the second one has to do with actually the substantive analysis that must occur. So presumptively, okay, we as the public and the news media, we have a right under the First Amendment, pretty much anything that goes on in an open court. Okay. That's the baseline rule. So in order for a judge, and let me get you the citation real quick. It's going to be Utah Rule 4-402-04 subsection 6. So anyways, this is the rule, the statute that governs, when judge can classify what should be otherwise public motions and proceedings as private. And so in order for the judge to justify and actually keep a motion or proceeding private, on the record, there has to be certain findings as dictated by this specific statute. So let me go ahead and read what that is. So in order for the judge to rule or order that something be private, like a motion, anything of that nature, it has to make findings that the interest favoring restriction, okay, so when they're kind of balancing the interest between the public having access to all these, which is baseline, that's the presumption, the court would need to, on the record, show that the interest to keep it private outweigh the public's interest to access to it, right? So again, what are some of the interests that could justify keeping it private? As we'll see in one of these, we're going to talk about, like, there was an instance where the information in the documents was about a very, very gruesome murder that, to the extent to where publishing it into the public record, needed to be censored, right? So again, sometimes there are interests that outweigh public disclosure, but to be honest, they should be few and far between, okay? But it also requires that the judge make a finding that no reasonable alternatives exist in order to protect the defendant's interest, but also protect the public. And so, with that being said, the system favors the courts using things like voir dire, jury questions, redacting certain parts of documents, like anything short of, full closure should always be the first resort. And so in order to classify as something as strictly private, the judge needs to make a ruling on the record, a finding to that effect. Okay. And so, okay, hold on a little bit more. They must all the requirements for the restrictions. So if there are restrictions, right? So if there is some closure, for instance, redactions and stuff like that, it's bare minimum. The court, if they're gonna make any of it private, it needs to be absolutely the bare minimum to satisfy the interest, the competing interests, the balancing of those interests in the case. Okay. Again, the court must consider partial restriction or redaction before a full sealing, which makes sense, right? And the court must make these findings on the record. They can't be implied or assumed, and they can't be conclusory, okay? And so that didn't happen, right? Because remember what I told you is that on 1/12, the motion filed 1/9. On 1/12 the following month, Monday, the court issues an order classifying this motion as private. Now, in that order, there is no analysis. There is no findings, according to the news media, right? So those are two things right there that just right off the bat, the news media is saying that, Judge, your order classifying this as private is not congruent with your standing order in this case, and it's not congruent with the requirements of Utah law. Okay, so that's just like right out the bat, this thing is invalid because your order is invalid. We're going to talk about the merits of the defense position here in just a second, but right off the bat, boom. As I've stated, all filings are presumed to be public, and defense must show why it should be made private in this instance. The media argues that because there is no substantive analysis by the judge in the order on January 12th, it needs to be revoked or it needs to be vacated is the proper legal terminology there. I apologize. It goes on to say, the failure of a district court to make the necessary findings is an abuse of discretion unless the facts in the record are clear, uncontroverted, and capable of supporting only a finding in favor of the judgment. Okay. And just so you know, the news media didn't get to see a copy of this. So really the basis for the defense's position here and the judge's ultimate order are completely unknown. Okay. A complete mystery. And so, just pretty offensive to the rule, to the statute, to the constitutional presumption in these instances. I'll continue. So, and they cite a case here, and I wanted to read the quote because it's pretty clear, but this is a Fifth Circuit case. It says that, most litigants, and let me preface this, is that this really shows the importance, and I've said this in the last live stream, right? Because media in this case is there to really represent our interest in fair and open, proceedings. However, that's not always the case. And so it's very important that the judge remains steadfast in basically, he, in this case, if the media wasn't there, would be the only one representing our interests. So it's very imperative that the judge be cognizant of these things and consistently consider the interests of the public in open court proceedings anytime there's a motion to seal or to keep any part of these proceedings or papers private. The case here says, most litigants have no incentive to protect the public's right of access. So the state or the defendant, ultimately, now you could assume that there's probably some cases where either side would want to be out in the media to create some type of, well, we would hope that they're not trying to taint, jurors one way or the other, but there might be a case where public support for one side or another might be beneficial in a case. But otherwise, most litigants have no incentive to protect the public's right of access. That's why judges, not litigants, must undertake a case-by-case, document-by-document, line-by-line balancing of the public's common law right of access against interests favoring non-disclosures. Sealings must be explained at a level of detail that will allow for an appellate court's review. And a court abuses its discretion if it makes no in favor of the public's access to judicial records and fails to articulate any reason that would support sealing. So basically what's been done here, okay? There's been basically sealed this motion and there was no real reasons given for it, okay? When it comes to protecting the public right of access, the judge is the public interest principal champion. And when the parties are mutually interested in secrecy, as in a sense it is here a little bit, the judge is its only champion, yet we also have the media here. So hats off to the media on this. I got to give, even though mainstream media isn't, our best friend in the world, in this instance, they're actually doing, something beneficial for us and something that at least I'm grateful that they're there, putting up this fight. In its response in the memorandum, the media relates its belief that the move for privacy is because the motion concerns evidence suppression. So it's their belief that this, on the 9th, the motion has to do with evidence suppression. And so I'm trying to think, is this a good time? Again, there's a difference between a motion to suppress. Okay, I'll just take the time right now. So pre-trial in a criminal case, there's a few different ways to challenge evidence, and it all just depends the situation, right? But one that y'all might be familiar with is what's called a suppression motion. Okay. And so in a suppression motion, a defendant is arguing that the evidence was obtained in an unconstitutional way. And because the unconstitutional acquisition of the evidence, needs to be suppressed, meaning that the judge or the court will not allow that evidence into trial. Now, in the context when we're talking about First Amendment public media right of access to judicial proceedings, our interest in having a full and open suppression hearing is, and we'll talk about a motion in limine next, it's a little bit higher than it is, or more important than it is in a motion in limine, and it's because it involves police conduct. So in a suppression hearing, obviously the basis asking for the evidence to be excluded isn't because necessarily it's inherently inadmissible, but because the evidence was gathered by law enforcement in a way which violates the Constitution. And so because it has that extra element of putting law enforcement's conduct on display in front of the public, the interest in maintaining those proceedings open is very strong. Okay. And then I'm going to say opposite, but in conjunction with that, there's also what's called a motion in limine. And I covered this, I think in the last live stream or maybe the one before. No, I take that back. It was covering the cover up when I was talking about the text messages and challenging the text messages, the authenticity or admissibility of them through a motion in limine, which again is a pretrial motion where the court rules on whether it believes that a piece of evidence is admissible or inadmissible. And again, just to reinstate or restate what I did last time, is that those motions aren't necessarily binding, meaning that if judge rules on a motion in limine pre-trial that it's admissible, inadmissible, still requires the proponent, the person that wants to get the evidence in, the party, must still try to offer that evidence at trial and get a ruling at that time, like a second ruling, and that would firm it up for appeal. Just having a ruling on a motion in limine, if you don't then go to trial and try to offer it into evidence, you won't have a grounds to appeal the denial of that evidence being admissible. So obviously, because the police conduct in a motion in limine isn't going to be part of the case or the motion, our interest in that being open to the public is a little less than it is in a suppression hearing, but still very strong. Okay. Still very strong. And as we'll see, just because a piece of evidence is admissible, inadmissible, doesn't by itself without more, whether the public, us, the media have a right to it. Okay. So let me go. So one thing, and I think I said this, is that, the media notes that the defense counsel has indicated that, this is going to be a continuing thing. They're going to be continuing to argue that a lot of these pretrial, and I'll say, I think they've argued that just about every single pretrial motion or proceeding should be private. And so the media notes here that, they've made it pretty clear that they're going to continue to be filing these types of motions, seeking to seal or keep private these motions and proceedings. So with that being said, the news media states that the defense is kind of operating off a erroneous assumption that for some reason there's this presumption that things shouldn't be open to the public. Okay. And so, and this has to do with, and really as it relates to suppression hearings. And so this is Richmond Newspapers versus Virginia, which is a 1980 Supreme Court decision. It's the first time the Supreme Court really established a First Amendment right of public access, in that it's inherent in the very nature of a criminal trial. Because when we look at the whole paradigm of legal proceedings in our democracy, in our society, really it's the criminal ones that we really want to make sure that the state isn't abusing its power, or the federal government isn't abusing its power. And so this First Amendment right to open access to the courts is particularly strong, and as the Supreme Court stated, inherent in the criminal process. Again, now that's not to mean that everything has to be open all the time. As we've seen, there are rules that dictate, sometimes things need to be sealed or kept private. But this, Richmond newspaper versus Virginia really established that firm, strong interest in criminal proceedings to full and open proceedings, particularly as it relates to the suppression hearings. Let's see. Next, they also talk about Waller v. Georgia, which is a 1984 decision. It says suppression hearings are often as important as the trial itself. In Gannett, as in many cases, a suppression hearing was the only trial. Okay, so that's another aspect I wanted to bring up here is that, suppression hearings are often dispositive, meaning that when a judge rules, usually it's a piece of critical evidence. For instance, in a drug case, if the drugs are found and located, seized, in contravention of the defendant's constitutional rights, well, then when the judge rules that, hey, you're not going to be able to introduce those drugs into evidence, well, that kind of kills the case. Okay, so that also goes towards why these suppression hearings have more force in being open to the public than potentially other pretrial hearings in a criminal proceeding. Let's see. So here goes a Second Circuit case. This is In Re Herald Tribune Company, Second Circuit, 1984. This is another one that the news media cites, and they say that it makes little sense to recognize a right of public access to criminal courts and then limit that right to the trial phase of a criminal proceeding, something that occurs in only a small fraction of criminal cases. Basically, criminal trials are pretty rare, right? Most of the time they plea bargain, okay? And a lot of that, again, dictated by how a suppression hearing turns out. There is a significant public benefit to be gained from public observation of a criminal proceeding, including pretrial suppression hearings that may have a decisive effect upon the outcome of a prosecution, okay? So that pretty much summed up this first memorandum in opposition to the motion to seal the January 9th. Okay. And let's just review real quick, really what the basis was for that. Well, and we'll work kind of backwards. One is that, they seems that the defense is operating off an erroneous assumption that there isn't, baseline a right to open public proceedings in criminal cases, particularly with suppression hearings. Obviously they just cited a bunch of case law that says, yeah, that's not the case. Second, the judge did not make the appropriate findings in the order in order to validate the January 12th order to keep this motion private. And finally, the news media was not given the appropriate amount of time. Actually, the 7 days under the current standing order in the court, they weren't given the time that the judge's own order was giving them to respond to this motion to keep this private. Okay. And so that's kind of the basis of the first memorandum in opposition from the news media. Now, next, they filed what's called a surreply. So, and as I was saying, these filing systems can get very, very confusing when you have multiple parties doing motions and responses and replies back and forth. So when you hear the name surreply, it's basically like this. Defense filed a motion. They filed a response. Okay. And then usually the defendant will file a reply. And then at times you get to file a surreply. And so this is what the media has filed. Now, to the best me looking at the filings, I don't think any of the defense's motions, responses, replies were made public yet. All I've been able to look at is the states and the news media's responses and replies, and none of them really go into detail. I don't think the news media has seen necessarily at least the original motion to make this thing private, and the state doesn't give any indication really what the, real basis of the defense's motion is, what it concerns, what evidence are we talking about, or even what kind of evidence are we talking about. So we're kind of shooting in the dark here on that. But in the surreply, the news media distinguishes some cases that the defense, I guess, brought up. Again, I'm unsure of what document they're looking at or responding to. However, I will go through these because there's enough in the media's response and reply here to really talk about the issue and understand as much as we can without knowing what exactly this is. So I'll go through it real quick. So this first case, Gannett versus Pascal in 1979, case out of the Supreme Court, they say that, this case did not concern the media's First Amendment right to court access, but instead concerned a defendant's Sixth Amendment right to it. So, and let me just back up and make this a lot easier. Basically, this Gannett case came before the Virginia newspapers case that we just talked about. And so at that time, the Supreme Court had not established this firm First Amendment right of access to the media and to the public. Okay. And so this Gannett case was before it was really focused on a defendant's Sixth Amendment right to a public trial. And so I'm not going to go into it in detail, but I do feel that the news media is right here is that, what they're talking about, this case that they're citing does not fit the facts or circumstances here. And it was this case came out before the Virginia newspapers case, which really governs what's going on here. Let's see. And so the media goes on to say, though, is that, after the Richmond newspapers case, consistently after that, the Supreme Court, other federal courts, state courts have consistently upheld this right, First Amendment right to open access for the media and to the public, except in rare circumstances, as we've talked about, where the judge makes really specific findings to make these things private. Hearing on motions to suppress, like certain other criminal pretrial proceedings have historically been and logically should be, open to the public, and the First Amendment right of access fairly extends to the exhibits used at such a hearing. Okay, so to the extent that they're wanting to attach exhibits of potential evidence, stuff like that, generally we should be seeing all that. All these things that the defendants filed that I'm saying I can't see, we should generally have access to that. And when we don't, there should be an order in the record stating the reasons exactly why we don't have access. And look, ladies and gentlemen, like a lot of other things in this case, we don't have that. Why did the judge hurry that next Monday? Okay, why did the judge hurry that next Monday and issue an order keeping this motion private when surely he very well knew that the media did not have the appropriate time to respond, and he surely didn't have enough time to consider? And then you got to ask, well, even if he was going to, scoot up and not give the media the chance, at least he would have done an appropriate analysis and had the appropriate findings in the order. So again, it makes you wonder, like, what was pushing to come out so quickly to make this thing private, not giving media and to the extent too the state a chance to respond to these things. It's a little weird. Not saying these things don't happen, but it strikes me as a little bit odd, just to be honest with you. And we'll go into this a bit more as we talk. The next one, State versus Archuleta. So this was a Utah Supreme Court decision, okay? And it did relate to certain documents, certain items of evidence to be brought up in a pretrial suppression hearing, okay? Now, the court in that case, again, this is a Utah case, the district court did exclude certain items of evidence, okay? Well, why was that? Well, in that case, and I think I mentioned this just a minute ago, in that case, and I did want to read, I don't know why I wanted to read this, but that case involved a very heinous murder. Okay. And the reason why the court didn't allow some of the evidence to be shown to the public in the public record per se is that it described this very heinous crime, like terrible. Okay. And just to give you some context, it said the district court denied access to specific evidentiary documents to the public due to the completely morbid and heinous content as it described the crime. The homicide was particularly depraved and had physical torture, certain forms of the R word, and massive bodily injury before being unalived, and also informed about sodomy, torture. Just really, really bad stuff that, when you come to know that, you understand. You're like, oh, okay, yeah. This was just something that was not material necessarily to deciding the substantive motion and was really just too graphic to put out there into the public domain, absent just really, really need to do. So again, the media here, they're stating, look, even though we don't know the exact basis of, their motion, we can say that we're pretty confident that we know enough about the circumstances of what went down here to know that there's nothing that gruesome that they would be hiding, right? We're not aware of anything that would be that gruesome where Archuleta, that standard would apply here. right? Because and that's not to downplay the graphicness of the video that we do have, right? That's not to downplay the graphicness of that video. However, it's not Archuleta, and moreover, again, there are lesser means that the court employ, like redactions and the like, in order to release as much as possible. But again, a wholesale blanket, sealing of a motion like this is pretty extraordinary. Pretty extraordinary. Okay, so lastly, they talked about United States versus McVeigh. This is what the defense brought up this case, right, in support of their motion to keep all this stuff private. Again, the media distinguishes this case. So in McVeigh, it really had to do with evidence being disclosed, what's going up on appeal. The evidence that was excluded had already been ruled inadmissible, okay, in a suppression hearing. And so, and not only that, the suppression hearing happened in open court. Okay, so again, factually very much distinguishable from what's going on here. And again, going back to the importance of suppression motions and, inadmissible evidence. Sure, if evidence is ruled inadmissible and it just lingering out there is going to continue to be prejudicial to a defendant for the media to keep putting it out there. Yeah. And essentially I'm assuming that's probably what happened in McVeigh. But in any event, the McVeigh evidence was for a suppression hearing. Apparently there was a confession or a statement that was gathered from McVeigh that was in violation of his constitutional rights. It was ruled inadmissible in a fully open suppression hearing, and it was a later disclosure, either on the way to appeal or setting the appellate record, is when it was sealed. Okay. So again, very factually distinguishable, as pointed out by the news media as to this case. And according to the media, and I tend to agree with this, this is kind of just a general statement, right, of how the media views the defendant, Tyler Robinson's defense, making these motions and trying to hide in public. They say that defendant has voluntarily brought an exclusion motion seeking a public court ruling, okay, presumably based on the content of the evidence at issue. Having done so, he cannot complain that the content of the evidence is now subject to the public's right of constitutional access. Okay. Okay, and then the last one I want to address here, and so remember when we started, I told you there was going to be kind of two sets of motions that I'm going to be addressing. And this next one has to do with the defense trying to keep out cameras and photographers, basically the media, from basic future proceedings. And so the way I took it, and again, I'm not able to see this because not only does the defense counsel want to make these things private, but the motion to make them private, to exclude the media, they also want that motion in proceeding to be private. Okay. Which is kind of a double Debbie Downer, I guess you could say, in terms of what we're doing, because we're trying to see everything, right? So this is kind of a double Debbie Downer, trying to have this motion to exclude cameras and TV access to the courtroom in a private motion, in a private proceeding. That's right. And if y'all remember correctly, I read a little bit from this one last time, because there's some beautiful wording in here, by the way, from the media. But yeah, so remember when I read it, it says, no one trusts what happens in a secret criminal proceeding, not those who support the prosecution, who wonder why the case was properly presented, not those who support the defense, who wonder whether defendants' fair trial rights were respected, and not even dispassionate observers who are deprived of their right to see how the judicial system works. And, it's right, because a lot of people suffer when this happens, right? I mean, because case in point, here we are. I mean, I'm here doing lives pretty regular, like talking about just time and time again, like, man, I wish we had this evidence to look at, so that way we can really start formulating our opinion and firm up within ourselves that there's no funny business going on, right? Just because from day one, I think most would agree that there's been some funny business going on. And, in this case and in others, when you're keeping these court proceedings private, regardless of whether there's merit to something funny going on or not, it just starts to erode trust and credibility. In this case, is just a 10x on that because of all the suspicious circumstances that we've identified surrounding almost every aspect of the case. Okay. And so, in talking about moving forward, when I said the news media basically states that they believe the defendant's just going to keep doing this. It's like every motion, every time courtroom, cameras try to come in the courtroom, they're going to consistently challenge. And the news media states, this latest iteration in what has become a serial drumbeat from the defense demanding a secret prosecution is perhaps the most telling. And so let me ask you that, what I just read, why on God's green earth, okay, would a criminal defendant per se want a secret prosecution? Now, again, in certain instances, if there's evidence going out there that's just going to be extremely, extremely prejudicial and just completely eradicate any potential for a 1 fair or 12 fair-minded jurors to come into for voir dire, sure. But normally, and I will say is that, the right to a public, the Constitution and our law favors open public proceedings in a way also to protect the defendant, right? Because in ancient times, in medieval times, right? Yeah, they had secret court proceedings, secret trials. And then, next thing you know, people are coming out of the courtroom being hanged, and no one in the public is any the wiser as to really what the legal basis, what the evidence was and stuff. And it just really erodes distrust in the public, distrust in the government, distrust in the courts. And it's just overall not a good thing. And so, I really like these statements by the news media. They go on to say, they want to deprive the public, talking about the defense. Well, hold on, take that back. Well, yeah, they're talking about the defense. They want to deprive the public from observing these proceedings, but they will not publicly explain why. They filed their motion to exclude cameras from the courtroom under seal, okay, and will not provide that motion even on an attorney eyes only basis to counsel for the news media, so they may see the purported and presumably slim justifications for their extraordinary response. Again, this is extraordinary, and it does not help for me, and I wouldn't imagine it helps for y'all in having some type of trust in the sanctity of these proceedings. Okay. They go on, they would rather litigate in the dark and have others do the same on issues of constitutional magnitude that go to the core of the court's fundamental promise of public justice. I just think it's very eloquent language, y'all. That's why I'm reading this. Because this repeated insistence on a secret prosecution with no mooring in the Constitution needs to stop. I absolutely agree. Every week seems to bring a new urgent request for unjustified secrecy, and now the defense is not even trying to defend its demands publicly. They want even secrecy decisions made in secret, right? So again, that's what they're saying, is that they're asking you to keep these proceedings secret, and they want that whole decision to also be secret, right? The whole thing's secret. So not only would we not know what's going on, well, we wouldn't even know why we don't know what's going on. Again, when we talked about the smell test the other day, this does not pass the smell test. It just doesn't. I'm sorry, y'all. I'm trying my best to have faith in this, but I feel that there's a breakdown in rule of law here. I really do. And I don't mean that to scare you or give you alarm. Okay. That's why I'm here. I'm trying to help us get a grip on this, so that way we can better understand, and that way y'all have framework for understanding what's going on. And hopefully we can, if we have to, start formulating some solutions in the future, their constant incantation that the case is somehow unique and has drawn significant public attention cuts exactly the opposite way. That is precisely why it's so critically important that the public be allowed to observe these proceedings and see the court in action. Ensuring defendants' rights are protected and the prosecution's ability to present its case is preserved. Again, these are bedrock principles of our system of justice, enshrined for hundreds of years. They are not controversial. This court should not depart from them. Okay. And so next, it kind of goes into Oh, okay. Sorry, I'm gonna get off the comments till we're done. Sorry, apologize. But anyways, let's go through real quick some of the two arguments as the news media does not even know what the defense's arguments are. Okay, so that's why I'm gonna go through these here with you because I'm trying to help them because I'm trying to help myself because it's crazy that we don't even know. You would figure just me as an attorney, I'll just tell you what I would do. My first inclination, if I was going to file a motion like this, seeking to exclude these cameras and stuff, if there were parts of it that I didn't want, because really, I mean, let's be real. The legal arguments and most of the factual basis should be okay for everybody to see. But yeah, if there's certain pieces of evidence or certain quotes or references to evidence within the motion that are going to be too prejudicial, just redact them. This wholesale move into complete privacy is very suspicious. But they go first. The primary argument the defense seems to be making is they have voluntarily included in their motion, okay, a number of public statements and public news stories they think are derogatory about their client, and they think they should not have to republish those negative stories in their court filing, even though it is they who are putting those statements at issue and asking for affirmative relief from this court based on them. So, yeah, so here basically what they're saying is, and again, they're guessing at this, right? We don't know this, but they're guessing that the impetus for asking total exclusion of cameras, things of that nature, and we talked about this a little bit the other day, the lip readers, videos being, infinitely dissected, things like that, and in a way, that's a fair argument, right? Sure, it's a fair argument. But again, if you want to make that argument and you want to cite to these different pieces, that's fine, but it doesn't mean you have to make the whole motion private. You can simply write your motion, any reference to them, enter a redacted version where, and I'll admit, when you're dealing with sealed documents, it's a lot of legwork because you have to send like a redacted version to actually go into the public record, with also a motion to seal with the original version. So there's a lot to it, no doubt about it. But the way I've operated in the past has always been on the assumption that, we would rather just pick out parts of it rather than try to redact the whole. And the news media also makes a good point here is that, they could just let sleeping dogs lie, right? If they feel that these articles and stuff like that are prejudicial, things of that nature, they could still come argue the point that they don't want the cameras in there. They don't have to use these bits of evidence that the media thinks they're using as the impetus for not, making their motion public. They don't have to use those bits of evidence. If they do, they can certainly redact them or try to, limit their exposure in some way. But when you're going to the court, asking for a public, in the sense that if the judge excludes all the cameras, all that'll be public. So you certainly want a public declaration, no cameras in the courtroom in order. But with that comes a little bit of exposure. Again, they could just let those articles and stuff that they feel are defamatory or prejudicial lie and use some other basis for this, right? So they're making good points here. But again, if you're a little bit confused on this, I think we all are. And again, it relates back to the first instance. We're not able to understand exactly what the point here is by the defendant. Here's a few good case law quotes though. I like these. What transpires in the courtroom is public property. There's nothing that prescribes the press from reporting events that transpire in the courtroom. And even if it were constitutional to do so, whatever interest might have been served by ex ante closure cannot be served by an attempt to put the genie back in the bottle, right? So again, there's already been so much coverage. There's already been evidence released to the public by state, right? So in a way, the genie's in the bottle. And what the news media is saying here is that actually the genie's out. They're trying to put the genie back in. So yeah, I get it. And so then they go in is that, second, and even more fundamentally, the defense's entire presumed argument rests on the premise that a defendant can never receive a fair trial in a high profile case, no matter how regular and thorough the court's processes are for seating a fair and impartial jury. It says the news media has already briefed it at length, the overwhelming authority supporting addressing potential juror bias and voir dire and other contexts. rather than in sprawling prophylactic closure orders that disregard the First Amendment. So again, they're just saying, Judge, the law prefers that you use for Dwyer these other techniques and procedures and processes that the law gives us to ensure that a jury is going to be fair and impartial. Completely closing off the proceedings pre-trial is by far not the preferred method. Okay. And then they kind of end on this notion that the judge in the court is really the main person, main institution there to protect our rights. And, in that, the judge needs to be making orders that are well-reasoned, making appropriate findings, et cetera, et cetera. And as we've seen, at least regards to this January 9th motion, the sealing of it, we didn't get any of that. Okay. Now, as far as the procession of the proceedings, okay, when the other day at the end of the court hearing the other day, judge relayed that on the 24th of this month of February, they will have an online court session where the judge will enter his order regarding whether the prosecutor is going to be disqualified. Okay. In that same proceeding, he indicated that he will start at that time setting the timetable to rule on these media things on the open access to the courts. So at this juncture, I'm assuming what he's probably going to do, because of these multiple angles on how open this is going to be, he very well might take all of these motions and then come and do one court proceeding, basically, whether it be oral argument and then issuing an order. And so I think on the 24th, we should know at least what the timeline will be and what it will look like, him making the determination on all the privacy versus open court access issues that we have going on here. Okay. All right. So that's kind of the lowdown. That's kind of the DL. That's kind of the line on where we're at as far as Tyler Robinson's trial, access to these proceedings and to certain motions and documents and evidence at this time. Hopefully we'll know more again at the end of this month. Hopefully, at least, I hope when judge does address this and new filings might come in. I'm going to keep an eye open for it, obviously, but hopefully on the 24th, at least we'll have some indication, where this might be headed. And I'm just going to express my opinion. I'm about to do a little bit of speculation. To be quite honest, without knowing, again, the basis of this motion, things of that nature, it's just really hard for me to really go too far or deep into speculation. Although, considering, that we talked about a potential challenge to the text messages, right? And it seems that this motion that they're wanting to keep private has to do with evidence. I couldn't help myself but do just a little bit of indulgence on wonder what evidence it is that they're, it's either a suppression hearing. And it's not clear to me whether this motion is a suppression or motion in limine. So let's talk about that real quick. Let's see. So what is the basis of the defense January 9th motions? Okay. So again, like I just said, I don't know it. Based upon what I've read, it seems like it's a suppression hearing. And so again, a suppression hearing has to do with the way that evidence was collected. Okay. So we got to think. And it's usually related to, normally it's getting it from the defendant. Okay. So this could be everything from, maybe they acquired the text messages that they're alleging in some wrongful way. Maybe they acquired Tyler Robinson's, a sample of his DNA against his constitutional rights. Maybe there was some type of confession that occurred that we're not aware of, okay, that they're seeking to exclude or suppress. Again, it's just a real open gambit about exactly what this could be, but I want to talk about the text messages real quick, because we talked about, Brian Inton came out with like two pretty close together. He had that one interview with the lady who was allegedly really close family member. I think they said it was the aunt of Lance Twiggs, which, if we were to believe Brandy and Billy, great work, Brandy and Billy, that wasn't true. the lady has some type of relation, but it's very far. And according to their information, that lady didn't have really much contact, if any at all, with Lance Twiggs. And then probably maybe a week or so later, there's this secondary conversation with the FBI agent. And even though the title of that video is talking about Lance Twiggs being in FBI custody, and that it really spent a lot of time talking about the credibility and essentially authenticity of the text messages, right? And so I just was thinking in the back of my mind, is it like, was that what some of us think it was, that there's this push to take back control of the narrative because the text messages have come under a lot of scrutiny, and rightfully so, right? And though, so then here we see these two news bits trying to, in my mind, rehab, like rehab the legitimacy of those text messages in the public eye. Is the defense trying to prevent that type of scenario from happening again, where it's like, this certain piece of evidence we know is being challenged by the defense, and then here comes the state, because obviously if we were to learn that, oh, they're challenging this bit of evidence, it's being admissible, credible, whatever it is, obviously we would be doing our thing, looking into it, blah, blah, blah. And obviously the state doesn't like that. And so I think, like with the text messages, what's their response? Well, and I say it's the state, some force out there, might I say, in my opinion, in my perspective, then had these different news segments published. Again, I'm not trying to rehab it. So is the defense trying to prevent that kind of situation where we become aware that they're challenging evidence, and then here we go with whoever is behind all this, trying to rehab or try to justify or legitimize it in our heads again? So again, this is just me musing, ladies and gentlemen. This is just pure speculation. I'm pretty lost, probably like y'all are too. And so I'm glad we're here doing it together. But again, I'm just trying to figure out like why, it's so important that this remain, this is, I guess you could say, a highly publicized trial. And maybe in my mind, because in our sphere, right, in our sphere of these YouTube channels, stuff like that, like the consensus seems to be that there's something funny going on. Most people don't really believe that Tyler Robinson was, at the very least, like the sole person involved in this. Okay. And so there's really a loss of control of the narrative. And so it makes you wonder, like, what, even though this thing's been televised, it seems in our sphere that it's beneficial for the defense. I don't know. I mean, other than, obviously we've been a little bit critical talking about, the potential for them to take certain avenues. And I don't mean it to be critical. I'm really just, in these prior videos, been trying to educate everybody on the possibilities, what the judicial system in many cases would be looking like, just to, let y'all or help y'all get to some type of reasonable expectations, right? But otherwise, I mean, as far as if the defense is truly trying to show that Tyler Robinson is not guilty of the underlying crime here, I mean, from our perspective, the media coverage has been pretty helpful in that endeavor, if you ask me. Now, obviously the mainstream media and maybe that's the opposite end of this paradigm, right? Maybe the defense counsel is only or mostly looking at the mainstream media, which, as we've seen, includes people kind of like, I don't know, would you consider Megyn Kelly mainstream media? I mean, even though she doesn't have work for her, I'm considering mainstream media, but her and others, right? There's just been a lot of statements out there that either implies guilt, people saying that he should be killed, these things. And so in that vein, I can understand why, they might want to limit publicity, stuff like that. But again, I just wanted to offer that there is on our end, I can see, our speculation, our discussions have seemingly been favorable to the extent that we want to see Tyler Robinson not held guilty if he wasn't, for murder anyways, being primarily involved. And so again, I'm just out here in the stretcher trying to figure out, is publicity in this instance that detrimental and that prejudicial? And moreover, I just have a hard time not believing that the procedures and the processes baked into the law, like for Dwyer and these, again, there's lots of process procedures where you can work to make sure that you have a fair and impartial jury. I mean, sometimes they transfer venue. Okay. again, and alternate jury pools. There's just a lot of different things that can happen. And in my opinion, I don't see where the media coverage, both independent and mainstream, have necessarily risen to the level of we need to keep this whole thing private. Okay. And so that's where I am personally at on that. I will, again, keep looking into this. I'm going to keep thinking about it. If any more, indication comes to my mind about, what this is, either the motion, the evidence that they're trying to exclude, or why on God's green earth would they consistently be taking this position, I'll let you know. Let me know your thoughts in the comments. I'm going to talk about a couple more things real quick, and then we'll jump on in and I'll take a look at y'all's comments. And yeah, anyways, let's see. Oh man, did I not include that stuff? I bet you I got it right here though. Okay, so here we go. Tomorrow, I'm going to do a live stream. Tomorrow's live stream, I'm going to let y'all know. I did a little digging into the current Epstein file release, and I found a 2019 lawsuit by Jeffrey Epstein victims from his first go round with the judicial system back in 2007, and that whole non-prosecution agreement, stuff like that. But anyways, I found a lawsuit in there that I want to talk about with you tomorrow, considering also in conjunction with the heinous job that they did disclosing victim names, okay, in this latest release. And ultimately, we're going to ponder the question, because I'm having real reservations about whether our Department of Justice is constitutionally capable. And I don't mean that like our Constitution, like internally, these people constitutionally capable of standing up for a victim of these billionaire elite PDF files. Okay. This lawsuit, when I read it and I learned about the way that these victims have been treated essentially from day one. Yeah, I've got a lot of concerns, And I listened to Thomas Massey today on a podcast interview he did. It was great. I love Thomas Massey, but he is giving, in my opinion, the Department of Justice way too much slack. Okay. Way too much slack. He, to him, because they were talking about the redactions and, the fact that it protects the perpetrators, a lot of them, and harms the victims. He said, look, I don't think it was intentional. He said, but I do think that they're capable of that level of incompetency. So it's not like he threw them a bone per se, but let me just tell you, in conjunction with this lawsuit I'm going to discuss tomorrow, I certainly do think it was intentional. I absolutely think it was intentional. I think absolutely 100% that Pam Bondi, Kash Patel, all those people, without question, will do whatever it is that they can to protect Epstein. Obviously, well, not anymore, but the people connected with him, all those people, they will do whatever it takes. Whatever it takes. Protecting the victims is not their priority. Not their priority. Protecting victims is not these victims. It is not the Department of Justice's priority. And it hasn't been, as far as I can tell, since the day that this came across their desk. So we're going to talk about that tomorrow. Okay. Next, I wanted to say we will be revisiting the TPUSA, the alleged fraud, misconduct, all that. And remember, we talked about the Arizona Attorney General letter. I'm going to be doing a live stream with the Adam Thomas podcast. Adam's my buddy. We've been talking Adam Thomas podcast. We're going to do a live stream together, and we're going to discuss, that whole process, that letter, and see what we can do about maybe getting that whole thing up and going for everybody. Okay. Lastly, so we've also been discussing, right, the possibility of Charlie Kirk still being alive. Okay. And I've told you that, I haven't written that off. And that, I was really in a lot of ways 50-50. So I'll say that Jesse on Fire, I don't know if y'all follow Jesse on Fire. He's obviously a content creator in the sphere. I love his show. He did a video today really going into some reasons why it's basically his opinion now that, that Charlie Kirk is alive. And in his presentation, he showed some video footage of Hunter Kozak, essentially a practicing, or what looks to be practicing his moves before the whole incident went down. I'm going to be doing a video probably tonight or in the morning. I have another tidbit of video of Hunter Kozak from that day. And it's weird because I haven't seen any of the other big content creators play it. I did send it to Baron a while back. I never heard back about it, but I'm gonna do a video on it. It's be real quick. It's like a 1.5 minute video clip. I just want to show you some other video of Hunter Kozak subsequent to Charlie's shooting, which also sheds light on, I feel, his involvement in a potential conspiracy, which obviously can also reflect on whether we think Charlie Kirk's actually alive or not. But Jesse, I'm going to be publishing that video here probably tonight or tomorrow. But wanted to put that video. Had sent it to Baron a while back, hoping he would put it out there. I haven't seen it, so I'll go ahead and do it. But yeah, this definitely needs to get out into the ether if people are starting to move in that direction. Or really just in the direction that this was a conspiracy. The Hunter Kozak video I got is pretty compelling too. And it's after Charlie Kirk event, but during that day. Man, so I think that is going to be it. Let's see. Let me make sure real quick. Yeah, so that's as far as my presentation. Thank y'all for being here. Yeah. So anyways, let me go to the comments and let's see what y'all got for me. Thank you, everybody. Yeah, and if you haven't, like, comment, subscribe, particularly subscribe, be very helpful. I'm going to keep these things going. I got tons of good content. I'm diving into the Epstein files. I'm digging into the thing with Trump and the lawsuit and the purported victim lawsuit was in 2016, but this incident allegedly occurred in about 1994. I'm going to be doing more on it, just kind of giving y'all a roadmap. But obviously, the Charlie Kirk, my number one on my content, y'all, is always going to be the Tyler Robinson trial. So as much as stuff as I have that's going to be beneficial and meaningful to provide to y'all, I'll cover that top in priority. Next, my priority is really on the TPUSA issues. Okay. And the reason why this is just because I think, as far as my subscribers, the community, I feel like my perspective and feedback on those things is doing the most public good on those two topics right now, but never going to forget the Epstein files. And we're going to be advancing a little bit too on the Trump thing, just because I'm feeling sort of called to do that. And so anyways, just want to give y'all a roadmap. Let's see what the comments say. Thank you, Susan. 900 subscribers is really showing growth. Well, hey, for me, I'm going on about 3 full weeks of posting videos. So I'm very smitten with it. And, let me say this is that I'm very pleased because the quality of my subscribers, or at least the quality of people who are showing up to my videos, regularly commenting, things of that nature, are not only high IQ people, but good-hearted people. And people that I feel are really dedicated to seeing us as a country and as a community through all this mess. And so I am co-committed with y'all in this mission. And so, 900 quality subscribers, my heart's full. I'm successful in that without question. So thank you, John. Let's see. Yay, channel growing. Thank you, Lisette, Linda. What's up? Hoaxing, what's up? Jack Rubenstein, they call Ruby. Oh, thank you, John. I appreciate it. Appreciate you like the legal analysis. Again, I try to keep my content based on, legal analysis, stuff like that. I've been trying to keep away from just me commenting on how I feel personally about a lot of things, but I've been finding that people enjoy that too. So I'll start throwing that in with more React videos, stuff like that. But I always try to bring my, what you're here for, my legal angle to it to the extent I can. So thank you. Thank you. 7 days doesn't sound like much time, Susan. Well, yeah, no, 7 days to respond to like a motion is pretty short notice. I guess it really depends, to be honest with you, Susan. Although I'll say this, it's the media. They've got money. As you know, they've hired good lawyers. And I don't know these lawyers. I just know how the media works. They've hired good lawyers. The lawyers are experts in this type of thing. they know the case law. They know all that by the back of their hand. They probably have, in their hard drive, pretty much this motion response already typed out because they probably done the same response 100 times before. So yeah, 7 days, but still though, I say that, but we are people, attorneys are people. We have schedules and, especially for ones like me who are kind of flying solo. Yeah. 7 days, pretty quick turnaround. If I were to get caught with something like that with a busy schedule, I would probably have to ask for an extension. But, with them, I think 7 days is reasonable considering it's the criminal case. There's obviously a timeline where, Erica Kirk is telling us to hurry up. So if Erica Kirk's telling us to hurry up, why would we give the media more than 7 days to respond? Come on now. Just kidding. Let's see. Erica said she wants cameras. She's in. Change of the courts. Never forget. What was that? Anyways, it would be interesting to if I wonder if we asked Erica, if we said, well, look, Erica, if we're going to have the cameras, that's fine, but it's going to take a few extra months in order for us to like sort all these motions and stuff on that out to approve it. I wonder if she would still be hot to trot since she's so ready to see this over with. I wonder, if she would still be hot to trot on the, speedy trial motion or notice. She didn't file a motion, she filed a notice. And I'll just say again, Jesse on Fire did a great like video, and I think it's a part of a series. But he's breaking down why he thinks that Charlie Kirk is still alive, and so he goes through a lot of why he thinks she's acting and pulls up video examples and stuff like that. It's really good, and I'm not gonna lie, it's got me really starting to kind of move in that direction too mentally. So, and we'll be talking about this as we move forward. So. Yeah, as a matter of fact, I might take a look at Jesse's video and maybe here next day or two, I'll do a react on some parts of it just to show y'all what I'm looking at that's compelling as far as, Charlie being alive. Let's see. Hilda B said of Benghazi, what difference does it make? She walks our streets. I'm not sure what that's referred to. I just wanted to. Funny name. Accountabilities, Snoops. What's up, Snoops? Accountability, lawyers, judges, and even witnesses might act more responsibly knowing their behavior is being recorded. It could discourage misconduct. I mean, you hit the nail on the head, Snoops. I mean, that's kind of the idea, the impetus behind these things of keeping courts open to the public because of, preemptively will hopefully prevent wrongdoing. And in the other instance, which I think might be the instance where we're at now, being able to identify when some funny misconduct has gone on and then, accountability flow from that. But good point, Snoops. Thank you, Hoaxing. I appreciate it. Again, thank you for do a poll. What will happen? Defense has because okay. I'll publish a poll. I think I can publish a poll just through my just main page. I'm going to do that. As a matter of fact, I'll just write that down real quick. Poll. Okay, so and I'm sorry, Hoaxy. I'm wondering what exactly you're referencing as far as a poll, but I've needed to start doing polls anyways, and that reminds me of something. Let me encourage everybody here that when you're in these live streams and stuff, or when you see these polls that are asking you, when it comes from content creators, okay, when it comes from people whose channel you trust, okay, I encourage you to answer them. Like when we're talking about TPUSA accountability, what do you think about this case? I mean, it really helps us content creators gauge, but I guess the main thing I want to say, and this is my trial lawyer self saying this, because if I were Tyler Robinson's defense attorney, I would have been in contact with every single content creator, including Barron, Trigger Smart, some of these people who've done a lot of really good polling on these issues to do with this case. Like they should have that much. I mean, that would be one of the first calls I'd make. If I was going to try this case, absolutely you'd want that information. It's just very helpful. So the reason why I encourage y'all to participate is it's really the trial lawyer in me encouraging people to participate in those things, because trial lawyers can use that information to really, really hone in their trial strategy. And just so you know, people pay a lot of money for stuff like that. For instance, what they call focus groups. So a lot of times when attorneys, big firms are going to go to a trial, they'll do mock juries, what they call focus groups, issue groups, where they talk about issues, do polls and stuff. And so this, the YouTube is kind of like and those things cost money, pretty good money. YouTube's a free thing for that. So, if I was Tyler Robinson's defense team, I would definitely be in touch with a lot of these content creators, asking for their polling data. Let's see. Joe Lennox, 2000, a closed trial in this case is a cover up. I would agree 100%. 100%. I mean, I think we're probably witnessing one to, can I pin down exactly what degree we're witnessing one right now? No, not necessarily. But, I would venture to say for sure if we see a closed trial, that's probably exactly what we're seeing. Let's see. Oh, Sis Vicious. Hey, everyone. I'm going to have to catch replays. Hey, how you doing? Yeah, well, sorry we couldn't have you now, but it'll be posted. Maybe she's not here. It'll be posted in a minute. We'll wrap up here in just a second. Let's see. The Warren report was a giant middle finger to the greater public. I need to look that back up, Sis Vicious. I do remember it being to that degree. I want to. It's just been a while since I've looked into that. Let's see. Susan, hoaxing. I need tinfoil for all the static in my house. Yes, indeed. Yes, indeed. Someone else saying, Susan also saying 7 days doesn't seem like a lot of time to file for the media. Again, it would just depend. But yeah, it's, I'll say this. Normally in let's say federal court, 7 days would kind of be the minimum that they would give you to do like in the rules. When you look at the civil rules, the rules of civil procedure, normally response or reply times are anywhere between 14 to 21 days. But sometimes there are 7 days. So, it is a thing. So 7 is kind of a standard number in a sense, but it's at the lower end of kind of the standard response times in the courtroom. Let's see. We do not have them to the Barney balloon, 1979. Not sure what you're referencing. McVeigh is alive. Let's see. Yeah, and that's good. I'm very happy that y'all in my chat are getting along and seem to have some pretty productive side conversation too. So I like that. Let's see. This may have already been said, but Greg, do you know George Webb announced his live today that you're going to be a lawyer in a civic case? Yeah, I know, and I've tried to clarify that with him. That's why I've said several times on my podcast that I'm not. And again, I've stated the reasons several times, but I just don't have the capacity to do it, both in the expertise doing class actions. I'm solo attorney. I don't have a firm to put it together. I've encouraged anyone, especially donors, if you think you have a claim and you want to assert a legal claim, please go find you local counsel just ASAP to do it. And this is a standing offer for everybody. If you need help finding a lawyer, really for anything, just let me know in theogenic@gmail.com. But yeah, I'm not going to be able to do the class action. If for some reason, some other attorney or individual, like for instance, goes to a law firm, here's my offer though, for real, is that if someone wants to kind of head that up, and it would probably best be someone who is a donor, who has a claims, but if someone wanted to head up trying to find a big, because you're really going to need a big law firm. So if someone wants to head up, a donor victim wants to head up trying to find a big class action firm to carry on the class action, I will help you totally in that endeavor. Everything from writing like a synopsis, maybe an email, helping you speak with the lawyers that you need to. I'll help in every single which way with that. But I'm not going to be able to have the capacity in many different respects to do it alone. But I do appreciate George. And just so y'all know, again, I have nothing wrong with George. I haven't really seen anything from him personally or to me that makes me. So I do appreciate George, doing that. He's been a nice guy to me, but I'll shoot him another email and just let him know. But we'll definitely, if someone wants to be the representative and kind of take the reins, I'll be glad to help them all the way through. Just like when the Adam Thomas and I do our live stream, we're going to be talking about a proposed letter and petition to the Arizona Attorney General. I will also help to the ends of the earth with putting that together as well, and even help presenting it to the Attorney General there. I just let me know. I got a lot of stuff going on, so I just can't spearhead those things per se, and I'm not a victim, and so I think on both of those counts, it's most meaningful, if we have a victim, someone who has standing and stuff to kind of take the reins, and so, but I'm here to support 100% without question. So thank you, Elena, for pointing that out. I'll get a hold of George. So thank you. Let's see. We the people may just stop paying taxes all at the same time. That would be a hell of a thing. Hey, if you're TPUSA, you wouldn't have to worry about the IRS coming after you, huh? Hey, maybe we can all write a letter to the IRS like Erica did, and just say, hey, we're not, we don't intend to pay our taxes. Maybe we'll get a letter back saying, yeah, we're not going to come after you for not paying your taxes. We don't have any questions about that at this time. Let's see. Helping the defense and the prosecution with facts and info, also pressing the courts for more cameras. Let's see. Yeah, so strange that the defense wants privacy is the opposite of what they should be doing. I mean, I feel so. I certainly do. I think it's, again, in our circles, the press seem to be favorable for Tyler. I mean, I do see where a lot of the mainstream media stuff hasn't been, but, that also makes me wonder too, is that, at this juncture, who's getting more reach across the country and across the world? Fox News or, this large contingent of YouTube creators like Candace and Barron's, people like this who are, that's a good question. So I don't know, but yeah, I mean, from my perspective, if I were his defense team, and let me just say this again, we don't know exactly what they're talking about. So, I mean, perhaps there is some piece of it, and knowing what we know about the state and the people potentially behind all this, we don't know. I mean, there might be some piece of evidence that they've disclosed in discovery that is just so extremely prejudicial that, at least with this suppression motion or the motion in limine, that you don't want any mention of it out there. It's so prejudicial. There very well could be that. So I'm going to reserve that, okay, for a possibility. But I would assume that if there was a piece of evidence like that, that the state would have already disclosed it. Yeah, just my take on the issue. I think every shot across the bow that the state has, or they think that they have, has been released to us. I certainly do feel that. Everything from the text to, the engraved bullets and all this stuff, I think they've put it all out there. I think that they had an interest to the extent we think this is some type of cover up, right? Then they had an interest early on to get, these pieces of evidence out there to get people trying to firm up in their mind that there's no question as to Tyler Robinson's guilt. So in that vein, I think that if there's any piece of evidence that could be prejudicial and bad for the defense, that it's already been shown to us. That's just my presumption. Don't quote me on that, but that's why I think this is kind of strange. Let's see. The defense is fake, Joe Lennox. Trust the defense team at all at this point. So hopefully I'm wrong. No one on this case seems to be taking the death penalty aspect of this seriously. They're playing around a person's life. It seems like he is innocent. I'll say this, Elena. I actually kind of had the opposite impression when I first started hearing about Tyler Robinson's defense, and I think I might have even saw maybe even a Brian Enter interview where they spoke with one of the defense lawyers, at least briefly. But my impression at that time was that they weren't putting enough emphasis on the guilt or innocence, and that they were kind of, the tone of what I heard was them more or less writing off his guilt, and really, because the whole discussion I saw really just focused on the death penalty. So, but it's interesting, your observation there, because it just, I think the fact that we've got kind of these opposite impressions really says something, right? Really says something. Let's see. Yeah. Wasn't there some kind of controversy? So yeah. In the Corrigini. Well, the one thing I can say, Joni, the one that I've been hearing about, and I keep telling you I'm going to report it, I just haven't found a lot of solid information, but apparently the Burt guy, who is one of Tyler's defense lawyers, who's pro hoc vice, meaning he's from out of state, California. Again, just kind of weird circumstance there, right? I mean, I think he's a big time death penalty guy or whatever, but they're saying that he's related to Terrell Farnsworth in some degree. If anybody's got any information on that, please let me know. But I've heard ramblings about it. I just haven't seen anything firm on it as far as like confirming up exactly what that relation is. But let me know. I'd be interested. But yeah, I've heard that too. And if that's the case, I mean, then that too potentially could, be a conflict, throw a wrinkle in the case. Obviously, it would be argued in a manner similar to what we're seeing with the prosecution. So, but again, it would be Tyler to raise it necessarily. It's obvious, it was obviously be his right, would be prejudiced. So we'll see. And if it is so and something happens and it might be a grounds for appeal later. And maybe they've set all this up like that, right? So maybe this is just a whole setup, and these pieces have been set up in a way which look odd to us now. But when it's all said and done, we'll realize that we just had an okie dokie pulled on us. I mean, I'm hoping to prevent that through podcasts like this. But yeah, very interesting. Let's see. Tyler's fictional too. He's playing around Joe Lennox. Let's see. Sorry, I'm really just kind of going through where the questions per se are. Craig, I'm still shook up from that VA. I'm sorry, Susan. Again, that's why I didn't play the video when I did it last night. To be quite honest with y'all, before I was going to, but I'm sitting here prepping to do that recorded video and re-listen to that. And I thought long and hard, and I said, yeah, no, I'm just going to, because we had been talking about it anyway. So I said, I'm just going to go up here and let y'all know, where these videos, give you the links, let you know what they are, my thoughts on it, what I'm looking into, and leave it like that. So I apologize if y'all watched it and it was a little bit much for you. I get it. But these things aren't pretty, and obviously what we're seeing released in the Epstein files, really gives credence, in my mind, gives credence to those statements in that video. So, but I'm doing some more research and investigation. We'll most definitely be bringing it to y'all. So yeah, I apologize, Susan. I don't see how they can allow the trial televised. The trial will become the laughingstock of all legal affairs of all time. So the question is, how can they get it off camera and not lose face? I mean, that's a good perspective. That's a very good perspective. Sharak Dare 72,000. I love the name. Reminds it sounds like chakra or something to me, but no, I love it. Yeah. We'll see. Will it be the laughing stock? Unfortunately, I don't know if it's going to be a laughing matter, right? If it goes as it's kind of been looking in this matter, and a lot of this is just tied to the fact that we just think it was a whole setup, right? And that's bleeding also into our opinions on the actual process itself. Well, it just makes you wonder. It's like, okay, if this thing ain't real in one way or another, either Tyler's like a patsy and this thing was all set up, or, Charlie's alive. Like, well, what would the normal procedure look like? I mean, me as an attorney, I'm thinking that, right? And so, yeah, I'm struggling with it too. So not to say that your comments aren't correct, but I'll just say that in either instance, I don't know if we're going to be laughing about it, to be quite honest. I don't think we're going to be laughing about it. I think it's a very serious matter. Although in figurative terms, right, you're certainly right. It's kind of like the laughing stock, but it's very serious business, Lisette. So if you look at I published a video last night. It's about the Trump 2016 lawsuit and allegations. I posted 2 links there from the testimony video. If you feel called, feel free to go check it out. We will be discussing that on later live streams and content. So when the jury goes to deliberate, they're going to have a lot of reasonable doubt. Well, I hope the defense hopes that. I certainly think. I think with the text messages, they should have some reasonable doubt. I think with
The fact that the crime scene was covered up should bring some reasonable doubt, and I hope judge at the very least will instruct the jury that that the covering up of the crime scene, that they should presume that that evidence was not favorable to the state at the very least. Uh, oh, oh, Peter Wells. Peter, evangelical Christianity is literally a psyop. I mean, I don't want to put evangelical Christianity all in one box, but I think if we're talking about the sphere or part of evangelical Christianity that's related to TPUSA and Erica Kirk and McCoy in them, I certainly do. You know what I mean? I certainly do. So, yeah. Let's see. Oh, Jeremy Mack, thanks for being so welcoming. This community already warms my heart. Oh, man. See, that's what I'm talking about. Thank y'all. Yes, I want to keep a very positive, upbeat, supportive community. And, look, I might be here tearing down public officials and stuff. I mean, not personal attacks, obviously, but like tearing down public officials. Well, I'll tell you back. PDF files, public officials, billionaires. Yeah, I'm going to attack them. But I'm not here to address down or attack anybody else. We're here to be fair, and I'm here to love. I like to live in a world where everybody loves one another. Really, it's hard at times. And I tell people too. It's like I love every person in their spirit, but I hate a lot of people's ways. And I'm fortunate to be able to separate that out most of the time. But it's hard. It's hard. There's people in this world that'll really put you in a bad spot emotionally and spiritually if you let them. And so it's an exercise in becoming very tough skinned. Let's see. What time tomorrow night for the live stream? I might do it probably tomorrow afternoon, probably maybe at the 4 or 5 slot. I don't know. I'm going down to the list. If you want to respond and say what you prefer, do y'all prefer? Now, normally during the weeks, I've been doing it kind of in the afternoons because of, Candace and Baron. I want to make sure everybody can see everybody that they like and not have to like choose. I did this today because we had some errands to run and stuff like that. This time I was probably going to go back to like a 3:30, 4 o'clock time tomorrow. Scrolling down. If you're at the keyboard, let me know what y'all prefer and I can definitely adjust. I absolutely can. Who bothered looking? Let's see. Afternoon is best, but any time is fine. Okay. Baron is going to live stream at 6 tomorrow. So whenever is good for you, Greg. There will be. So look, I'm just gonna stick with my 3:30. We're gonna do 3:30 tomorrow. We'll do the 3:30 live stream. Probably keep it to about an hour or so. It may be less. That way y'all can have a break and eat some food or do what you need to do for if y'all want to watch Baron and stuff. So we'll do that. We'll do it about 3:30 tomorrow. 4 p.m. EST. That's what Virgo said. Okay, we'll do that. 4 p.m. EST. Bam. Set on it. We'll do 4 p.m. EST tomorrow. Let's see. What did I say I was going to cover tomorrow? Oh, yeah. So tomorrow we're going to be talking about the lawsuit that I found in the Epstein files that gives me much pause and reservation in my belief that the Department of Justice from 2007 to now, any iteration of it, are constitutionally capable. And I'm not talking about the U.S. Constitution. I'm saying constitutionally capable of protecting victims of billionaire pedophilia, okay? Or high-level official pedophilia, right? I'm going to present that case to y'all tomorrow. And just the initial showing, right? Because I think I'm probably going to find more and more and more as I go, but based upon their redaction record here in this last release, in this lawsuit that I see, is putting me where I tell you I'm at. I don't think that they're capable of doing it, and it's sad. And tomorrow too, I'll share a little bit with y'all about, why I'm able to really empathize with these victims a lot and what it feels like. Cause I've been in a scenario where you have been terribly victimized And the people, entity that are supposed to protect you are the people who are not protecting you, who are outing you, and very well might hand you back over to the people who victimize you. I've been in that situation before. So, and I'll relay a little bit of that tomorrow just to give y'all some context of why I'm empathizing with the victims. It's a very terrible situation to be in. I feel so bad for them. So anyways, love y'all. Much love. I'm fixing to go eat, watch some videos, go to bed, but I'll be up here 4 p.m. ES time tomorrow. Y'all got the subject. Y'all got the time. Thank y'all so much from the bottom of my heart. Please share, like, subscribe, and we will be back tomorrow. That's all I got. Thank y'all. Much love.